These are people that you're going to have a relationship with in some way or another. They're coming in as new partners. They're coming in as new employees. They are former partners, but still, have money in the company. They're investors. These are people that you're going to have some sort of relationship with going forward, and you want to make sure that everybody's needs are getting met and that you try to figure out up front so you don't have headaches and hassles and disputes later on.
Welcome to the Fueling Deals Podcast, the podcast that teaches how to accelerate your business growth through all types of deals. It's time to fuel up, so buckle in with your host, Corey Kupfer.
There are only two ways to grow your business: organically through sales and marketing and providing great products and services, and inorganically through deals. Too many companies focus only on the first way, organic growth. Welcome to the podcast, which will help accelerate your business growth inorganically. My guests are a huge variety of deal makers and experts on all types of deals who have personal experience that can help you grow, get clear, learn best practices, and avoid mistakes. We discuss everything from large, complex mergers and acquisitions to smaller deals that you can do even without significant capital. So today's a solo cast, and I want to talk about some things that came up, were triggered by a conversation or two I had recently with clients. And it's, sort of going to get into a combination of structuring business partnership deals or structuring when you acquire another firm and you bring in people who want to be involved, in the management. Let's say you have a founders class and employees, now these new people you're bringing in. So it's going to get into some structuring stuff. And it's also just going to get into some negotiating things and also sort of what's appropriate or the factors to decide on what's appropriate to give and not give in certain situations. So one client I was speaking to is in the wealth management space, and they manage a lot of money, and they're thinking about doing an acquisition, and the other team, which brings a lot to the table, they're smaller, but their revenues are good, and they bring another aspect of in the space that will benefit this client, an area that they don't that they don't do. Again, I need to be careful. I don't want to give away any confidences. So it's just a particular segment of the market, gives them access to additional set of services and potentially additional clients that they don't have now, and it'll bring in another, let's say, add about 30% of revenue to their bottom line, maybe 40. So it's a significant, deal for them. And some of the questions are, okay, they currently have a capital structure that has a founder's class of equity. And that founder's class of equity has certain rights. It has non-dilutive rights, which you always have to be, let's talk about that for a second there. A lot of people want non-dilution. Sometimes investors want non-dilution, and in many situations, I'm actually not a fan of having non-dilutive rights. You got to be careful because any kind of non-dilute can hamstring your ability to do deals later, right? Because if you need more equity, et cetera, the pool that's dilutive is smaller because you have certain people that are non-dilutive, and it may or may not be fair. But in this case, and we've definitely done it this way, where there's a founder's class of equity that has some level of non-dilutive equity for being the founders, for taking the risk, for creating the platform, for doing all that stuff. And then there's a pool of equity that's available for the additional people that they're going to bring in through onboarding, hiring or acquisition. And that's the majority of the equity, but there is this piece of non-dilutive that the founders have. Okay, so now you have a situation where it's not a small hire or even a small tuck-in kind of acquisition, but it's a significant deal that represents a good portion, in this case, like I said, maybe 30, 40% of revenue and profit, and they bring this other aspect. So if I'm representing the team that's coming in, right, I'm going to want to say, okay, I know I'm in a minority position if we just do things sort of straight, meaning that when I say straight, I mean where, let's say, we just divide equity by relative percentage of, of profit or revenue or EBITDA or whatever other multiple. But I say, wait a second, that's going to be, if I'm in the minority position, that's going to put me in a position where I effectively don't have any say. And especially if I've been running my own company and have had total say, that might be difficult to swallow in kind of a deal negotiation. right? So, but at the same time, the founders of the bigger company, of the acquirer, are going to say, well, wait a second, we're the ones that founded this thing. You're coming into our platform. How much, say or rights do you want to have? So the first, you always have this decision on voting, control, management, participation, and say. And it's not uncommon. And in this case, we spoke to the client about, they've got, I think it's 3 people on basically their executive team and management. And they're bringing in a multiple person team. But there's one bigger main owner, and it wouldn't be unreasonable. And again, I'm not providing any particular legal advice to anybody else's situation. It is case by case, but depending upon the level of what they're bringing to the table, it wouldn't be unusual potentially to add one person at that level to the management team. So they become one of 4. They still can get outvoted, but at least they have a seat at the table. They have a say. They have a level of transparency, into things. So that's one of the factors that comes up. The other thing that happened to be the case in this, in actually, there's a couple of situations I'm sort of combining here because to illustrate several points and also not to have it be, identifiable to anybody. Not that you can probably figure out who it is. Anybody's gonna be able to figure out who it is. But again, I have attorney-client privilege, so I'm always careful. So, the other thing that comes up sometimes is, well, what are the rights, the relative rights of the different classes of equity? Because there might be things like, so we talked about voting. Sometimes there's preferential voting where the founders get multiple votes, and even though other people get to vote, or sometimes there's voting and non-voting. So does the incoming people get a voting class of equity? And let me make a distinction here, because I talked about adding somebody to the management team. Depending upon how the entity's set up, for example, if it's an LLC, it could be managed by its members, meaning everybody has a vote, or it could be managed by managers. And then being added to the board of managers gives you some say over whatever decision-making has been set forth in the operating agreement and the LLC agreement for that entity that has been delegated to management. But there's still a series of decisions that are on a membership level, either by contract in the operating agreement or LLC agreement, or if it's a corporation in the shareholders agreement. And also, in many states, there are a handful of decisions that members or shareholders, owners, have a right to, like, for example, on merger or sale often, or dissolution under state law. So there's 2 levels of voting often. If you're not a member-managed LLC, if you're a corporation, or if you're a manager-managed LLC, there's 2 levels of voting and control decisions to be made. And do the new people participate in management? And then if they don't, what level do they participate in at the member or shareholder level in terms of having votes, decision, no votes? Are there preferential voting rights for certain classes? So those things need to be taken into account. And then, are there differing economic rights, right? Sometimes the preferential treatment of founders' equity has to do with voting and control, but sometimes there are also preferential economic rights where there's a certain return or a percent that comes off the top before the profit distribution is divided amongst others. So do they come in at a different level? Or do they come in, sort of as a founding, class because they're bringing enough to the table? So these are the kind of decisions that, you've got to make. And some of it is really corporate structuring and what is possible. And in large part, there's some exceptions, but the truth is it's mostly governed by contract. And outside of, for example, those things that shareholders or members, at the ownership level have to be able to vote on by state law, or maybe have veto rights, or sometimes they have rights to force to be bought out. But there's a limited scope of what's governed by law. Most of the rest of it is just governed by contract. So you can do almost anything you want. So the question is, can you negotiate? What do other people do? Not that should automatically govern what you're going to do, but sort of what's standard in the industry, what are the expectations, what are the options? So that's, one of the things we certainly help clients think through. And then there's the negotiation, the relative value that people think they bring. Should they come into the founders class when they're not founders? Well, in a lot of cases, I say, no, listen, somebody who's not a founder, there's a difference between founding a company and joining one that's existing. The risk level is lower, the systems are there, et cetera. But in one of the cases that I'm thinking of for a client, remember, they're buying another existing company. So the management of that entity are founders. They're founders of their own business. So they did take that risk. They did do all the things that the founders of the acquiring company did in their company, and that's part of what's being bought in. So they want to be valued for that. So there's an argument that, one or more of them might belong in the founders class. But part of it is the relative value that's being brought, not only in terms of, let's say, revenue, EBITDA, profits, et cetera, but in terms of sort of maybe scope of services and future value that could be added to the table, and expertise and those kind of things. So those all have to be weighed. And listen, let's face it. Part of the issue here is so far we've been largely talking about structuring and thinking through it logically. And those things are important, but there's always going to be a human factor, right? There's always going to be an ego factor. And, getting somebody who's a founder of a separate entity to come in and give up their rights of control, their rights, so there's different levels. So one, they're probably going to give up their rights of control if they're a smaller company merging or being acquired by a larger one, because nobody in the large company is going to let them control decision-making. So one, they've got to get past that hump psychologically. Second of all is the right to at least have a say, to have a vote, to participate. And whereas you might say, well, if they can get outvoted, what's the difference? For a lot of people, it makes a big difference, right? Because there's a difference not even having a seat at the table versus having a seat at the table, being able to give your input, try to influence your partners, and also have that transparency and full visibility into at least what's going on, than not having it at all, even if you can ultimately be outvoted. And then there's another piece where even if you don't have that right to be, to control decisions because you're going to be outvoted, well, maybe there's situations where you want, in specific limited circumstances, the right to have some sort of veto right or say. So, in another situation where I'm advising, somewhat recently, we have a situation where there's a couple of retiring partners who are still going to own equity in the firm. The firm's not in a position or desirous of buying them out totally because they're deploying capital for growth. So they're getting partially bought out. They're still going to have an economic interest in the firm. And the question is, what decisions should they continue to have say in and or control over? Well, let's take an easy class of decisions in that case, which is decisions that, because they're no longer involved, right, they don't necessarily have voting control over, but that would adversely affect them to the detriment of them, but to the benefit of the others. So, for example, if I am an active owner in a company, along with a couple other people, and there are a couple of retired partners, well, it might be in my interest to give myself and the other active partners a raise, a bonus, a bigger expense account, things like that. But obviously, that's going to reduce the money that comes to the bottom line that will be available to be distributed to the retired partners. And they're not there working to participate in the increased compensation or bonus or expense accounts. So those are things that a retiring partner, would legitimately want to limit in terms of the calculation of what comes to them. But then what happens with other decisions where there are investments made where they don't particularly benefit the active owners, but they do reduce the amount available for distribution. So it might be things like acquiring another company or expanding to a new office or hiring more people. And the active people might want to do that. And the retired people might want to say, well, I understand how that could help the company grow in the long run, but I need, my distributions now, because that's what I'm living on. So, those are all of the kind of things you end up negotiating in these voting and control and decision-making rights in various scenarios, whether it's when you have partners, who are not active anymore, but are still owners, or you're bringing in new people through an acquisition or key people, high-level hires. And by the way, similar conversations come up. I mean, I've got another couple of situations where we have investors and what control rights should they have? They have a minority ownership interest. And what is that set of what we normally call extraordinary transactions or extraordinary actions? So buying the company, selling the company, maybe taking on loans above a certain amount, or making capital investments above a certain amount, or any committing to certain liabilities above a certain amount. Who should have control over those types of decisions? So these are all the things you have to work through when you're doing deals, either bringing in an investor, doing an acquisition, tuck-in, key strategic hire who's getting equity, or having partners retire. And these are all situations, for example, that we're advising on or have advised on, and we do it regularly, but they happen to be situations we've been handling over the last couple of months. So, a lot of this is nuanced, and it's why you want to get advice from people that you have experience with. That could be tax implications as well to some of these kind of transactions. What you really want to do is think through the legal structuring, think through the tax implications. But then also, obviously, you want to think through the personal, interpersonal. These are people that you're going to have a relationship with in some way or another. They're coming in as new partners. They're coming in as new employees. They are former partners, but still, have money in the company. They're investors. These are people that you're going to have some sort of relationship with going forward, and you want to make sure that everybody's needs are getting met, and that you try to figure out up front so you don't have headaches and hassles and disputes later on. And you want to take into account personalities, needs, and what is in the best interest of the company. And sometimes those are challenging negotiations, is challenging things to structure. But of course, getting the right advice is part of what helps with that. And also, staying calm and trying to think about it objectively. And, I'll give you an example in the case of where we're structuring for the retiring partners. Well, they're going to be other partners retire in the future. So whatever we figure out now for this first set of retiring partners will affect some of the people who are on the other side of the table, so to speak, today, because, 2, 3, 5 years from now, it may be them that is the retiring partner. And they're going to need to live with the implications of the structure that's put in place for retiring partners, right now, which doesn't affect them, but it will affect them in the future. So that's something to take into account as well. You want to try to do something that is in the best interest of the company and everybody on sort of a neutral basis, which is why, by the way, when we do these things in shareholders agreements, operating agreements, et cetera, when companies are starting, it's often easier because we don't know who they're going to affect. I mean, sometimes we have a situation where there's a senior person and some junior people, and we sort of know, and we're anticipating in the agreement that they're going to phase out in the next 3 to 5 years, and we know it's going to affect them. But very often we have people who go into business together, and yes, they may have some differing ages, whatever, but there's no guarantee in terms of who's the one who want to retire first, or will get become disabled, or certainly will die. I mean, anybody could get hit by the proverbial bus tomorrow. So in those situations, we don't really know for sure who it's going to affect. We might be able to, take odds on who it's more likely. And it's often easier to come to these decisions up front and structure up front for this stuff because we don't know who it's going to impact. Whereas if we have a particular situation, and sometimes it's like that. I mean, if you're doing an acquisition, right, you're not going to, you could have planned in your capital structure, and sometimes we will try to do that for companies that know they're going to do acquisitions, but you're still going to end up with a negotiation with the other side. And while I believe in creating models and holding to them the best you can, and trying to do deals that aren't, all over the map in 5 different structures, there are times when, like in this one example, where it's a significant enough deal for the company, where you're going to want to make some concessions and or negotiate certain, rights because of the significance of the deal to the company. So you can't predetermine it, and you're going to have to address a lot of these issues. So those are just some of the things that have come up in recent, deal structuring and negotiating and strategic thought that we work with clients. I think it's one of the things that my intention of this podcast is for people to start getting familiar with these kind of things, getting familiar with the kind of at least questions to ask, decisions you need to make, factors that you should be taking into account, and all the different types of deals that come up, so that when it comes to your time to do these, you are steps ahead, hopefully, And listen, obviously, we'd love to help you if we can in any way. And you getting to know us through this podcast. But frankly, my goal is to give value and information so that when you get to that next time, whether you work with us, you work with anybody else, you've been able to you've heard these issues. They're not new to you. You've been able to think through them, and you're thinking through them further in advance than you may otherwise. So hopefully this was helpful. These are some of the things that in real life, several of my clients are thinking about now, doing now. We're helping them with. So I appreciate your time, listeners. So thank you, Fueling Deals listeners, for tuning in. Remember, there's only one difference between companies that grow inorganically and those that don't. And it's unrelated to size, amount of capital, or any other factor. Other than that, the owners and executives of companies that do deals make a decision to do deals. And then they take action. Well, it's time to refuel. So until next week, Corey Kupfer signing out.
Thank you again for tuning in. Be sure to leave Fueling Deals a rating and review on iTunes and Google. Check out all our episodes at fuelingdeals.com to find out more resources to accelerate your business growth.